Hi, I'm John Kelly. I'm an attorney who's handling vulnerable adult cases. In this final chapter, we'll talk about the family's journey after suspected abuse or neglect, the emotional reality, the practical steps, and how the legal process weaves into the fight to protect someone that you love. Now, we've covered a lot of ground: the mechanisms of harm, the settings, the injuries, the evidence, the legal theories, the damages, and the defense tactics. Now we can step back, talk about what it looks like in real life. Because the truth is, these cases don't just happen in charts, they happen in families. And the family's journey often follows a pattern. Even though every story is unique, there's common paths. Now let's talk about something that is unique in vulnerable adult cases. The resident may not be able to tell the story, so the family becomes the storyteller, and the body becomes the evidence, and the records become the timeline, and the experts translate it all. That's why these cases are so important and why they require a particular kind of care in the legal approach. So we'll talk about a composite story, the Carter family. Let's bring this together with a story, again, a hypothetical, but built from patterns families often describe. So the Carter family, their mother, Elaine, is 79 and living with moderate dementia. She is forgetful, but she still knows her daughters. She laughs at old photos. She loves church, music. She needs help with bathing and medication, but she's still Elaine. After a hospitalization for pneumonia, the hospital recommends rehab. The family's overwhelmed. They choose a facility that looks clean, has friendly staff, and promises strong memory care support. For the first week, things seem okay. Then the daughters notice changes. Elaine's hair is matted. Her nails are dirty. She smells like urine. She seems unusually sleepy. They ask the staff, and they're told she's just adjusting. She's confused, and she refuses showers. One daughter visits on a weekday morning and sees something else. Call lights are ringing down the hall, unanswered. A single CNA is moving fast, eyes tired, doing triage. Elaine is sitting in a chair, slumped, unattended. The daughter's stomach drops. She doesn't know exactly what's wrong yet, but she knows the vibe. She knows the math doesn't work. A week later, Elaine falls in the bathroom. The facility calls late, after hours. They say Elaine tried to go on her own. She is sent to the ER, diagnosed with a hip fracture. Surgery happens. Elaine returns weaker, more confused. At this point, the family is in full crisis mode. They request a care conference. They ask for a fall prevention plan. They ask about toileting assistance. They ask about medication changes. They get vague answers. They get phrases instead of facts. Then 2 weeks after the fall, they find a wound on Elaine's sacrum. It's not a small sore, it's deep. It smells. Elaine cries when they gently reposition her. The facility says, "We're treating it." But the family has learned not to trust the words without proof. They photograph the wound. They take Elaine to the hospital. The hospital documents an advanced pressure injury with infection. She is admitted for IV antibiotics. At the hospital, a nurse asks the daughter a question that hits like a hammer. How long has this been there? They don't know, and the not knowing breaks their hearts. The daughters file an APS report. They file a complaint with the licensing agency. They request the records. They ask the facility for wound logs and turning documentation. Then something changes. The facility becomes defensive. They start saying Elaine was non-compliant. They start saying she refused care. They imply the family is overreacting. Elaine's hospice course is complicated. She becomes delirious. She aspirates. She develops pneumonia. She declines. Within months, she is placed on hospice and she passes away. The daughters are left with grief and a question. Was this inevitable, or did neglect accelerate and worsen everything? They meet with an attorney. The attorney requests records, sees Elaine's care plan, lists her as high risk for skin breakdown. Turning was ordered, skin checks were required, weights were supposed to be tracked. But the turning logs are sporadic. Documentation is copy-pasted. The wound appears in charting days after it must have been present. There is no timely escalation. Staffing records show chronic shortages. The case is filed. Defense argues she was old, she had dementia, she refused care. Pressure injuries can happen, but the plaintiffs show a timeline, photos, hospital documentation, and expert testimony explaining preventability and suffering. In mediation, the defense offers low offer. The family refuses this. They are not chasing a jackpot, they are demanding respect for what happened. As the case moves forward, more comes out. Staff felt pressured to chart tasks completed even when they were not. The management knew staffing was inadequate. Eventually, the case resolves with significant compensation. The daughters use the funds to pay for the medical bills. They cover the cost of the family incurred. They support their father, who depended on Elaine's caregiving and presence in ways money can't measure. But the daughters also do something else. They speak to regulators, they share documentation, they push for change, they keep Elaine's story from disappearing. On the day the case resolves, one daughter says something that captures why the case matters. We couldn't save her from dementia, but she didn't have to suffer like that. That sentence is the heart of vulnerable adult cases. You cannot stop aging, you cannot stop disease, but you can stop neglect. You can stop cruelty, you can stop the business model that treats care as a cost to be cut. Now that we've gone over a story of a vulnerable adult, I'd like to talk about retaliation fear. This is the question of, will they treat them worse if we complain? This is a fear that's real, and families worry that if they speak up, the staff will take it out on them and the resident. Most caregivers are not cruel, but in a dysfunctional facility, retaliation, subtle or overt, can happen. So how do you protect your loved ones while you advocate? Increase your presence if you can. Bring another family member or friend to the visits. You can put concerns in writing, calmly and factually. Ask for care conferences with the management present, and use outside reporting channels. You can consider a private supervision as a short-term bridge if necessary, and if you feel the environment is unsafe, plan a transfer. As an attorney, this is another reason that we early get the documentation of these matters. It reduces the facility's ability to isolate the family and control the narrative. If you find this information useful and you're dealing with any of these aspects that we've covered, please feel free to reach out to us at the Kelly Law Team. I'm an attorney that handles these cases across the nation. You can reach me at 602-283-4122.